afternoon now.
She's very helpful because she
Good afternoon, everyone.
Good afternoon.
Yeah, we had a slight technical difficulty. That's why we're not on 12, but we're fine. So let's jump right into it. How are you enjoying the weather?
Wonderful.
Yeah.
Wonderful.
Well, I am deep under one blanket, so I ain't up for the rest of y'all.
I was waiting on that response. I said to myself, I wonder who's still wrapped up under blanket and saying, thank God we don't have to go to class.
Exactly.
Yes. If it was physical class today, I probably would have seen 3 persons. And Trico would have been one of them.
Oh yeah, I'd be there. I getting my money's worth.
Okay. All right. So let's start. Who's going to go first? You don't have to go in any particular order.
Miss Archer, before you start, I'm a newcomer, so newbie.
That's
I said a newer. My sisters and I use that word. Sorry.
Okay.
So I'm Sandy Lockhart. I just wanted to say hi to everybody. I did have a chance to listen to the recording from last week's session, so I'm scrambling to catch up.
Okay, but we could always pull you in and then add a later date. There are lots of cases, so don't worry about it.
Yep, I'll try and chime in as best I can.
Okay, not a problem. Okay, so I know Trico.
Okay, sorry, is it me or I'm getting like a feedback?
No.
Not here.
No.
Okay, it must be me
I'm
then.
not
Let me
getting
check
either.
my stuff.
Adjust your microphone, maybe.
Yeah.
Yeah.
Try that.
Let's go, Trico. You're first.
Oh, this is Adams and Cape Industries.
Mm-hmm.
There's an unfortunate case with asbestos.
Go ahead.
Mr. Adams was trying to sue Cape Industries in the UK, I guess, for his condition. Asbestos was being mined in South Africa and being shipped all over the world, and I guess including the United States, where this case originated. I believe it was a class action, was successfully consummated in the United States, and they tried to bring it to the UK. The UK courts were not having any of it because they're saying that despite that they could prove that it was a single economic unit, the corporate veil could not be pierced to pin liability on a company that was legally and properly incorporated in the United Kingdom, and so they enjoyed the benefits of a separate legal personality, and its shareholders and directors, I suppose, were I don't want to use the word immunity, but were not affected by the actions or any lawsuit that was brought in the United States. So in the I believe it was the House of Lords, whatever, they dismissed the case and saying that the litigant had no recourse.
Yeah, in the Court of Appeal.
Court of Appeals, sorry, I didn't see anyway, yes, I accept what you say.
Okay.
Yeah.
So as a preamble, when we talk about lifting the veil or piercing the corporate veil, there are certain categories that the court would look at in terms of situations where they will ignore the separate identity.
Yeah.
So one is when it's where they could find that it is in the public interest. The second one is when there is an evasion of legal obligations. Versus Cape Industries was one example of that. The third one is where there is an abuse of legal procedures. And fourth one is when a company is acting as agent for its members. The fifth one is when the company is acting as a trustee for its members. And the last one is in the case of group companies. So the one that Trico just gave us, that falls under evasions of legal obligations.
Mm.
I think Chanel, you have Daimler. Is Chanel on? No, she's not. Jolene, you have DHN.
Hi, yes, I have DHN. Hold on. I have DHN Food Distributors versus London Borough of Tower Hamlets, 1976. So this is a case where the business was on, it was a business that distributes groceries and stuff like that. They owned by DHN, and the land that the business was on was owned by its wholly owned subsidiary, which was Bronze. And the council, Tower Hamlets, they had acquired the land owned by Bronze, which DHN operated its warehouse on. The council was saying that Bronze was entitled to the compensation of the loss of the land. However, DHN was arguing that they should also be compensated as well, as they would have due to the disturbance of the loss of business on the property. So they argued that since the parent company, which is DHN, owns all of the shares of the subsidiary, they also in turn own the land as well. And I think the judge, they ruled in favor of DHN's argument.
You're asking or telling us?
Okay, I'm telling you that the court ruled in favor of DHN argument, as DHN and Bronze were part of a single economic entity, and therefore they were entitled to compensation for the loss of business.
Okay.
Is there anything else? Any details? You have any questions?
Now they're all kind of quiet today. Yvette, El Ajou. I think for some people, they have to read it for themselves.
Okay, would you like me to read out a small portion of the situation of how it played out?
Yeah, that would be good.
Okay, so hold on. I have it right here. So the business was owned by DHN, and the land upon which the business was operated was owned by a wholly owned subsidiary, Bronze. The council acquired land owned by Bronze on which DHN operated its cash and carry warehouse. The council submitted that while Bronze was entitled to compensation for loss of market value, DHN was not entitled to disturbance loss because it did not have any interest in the land, either legal or equitable. DHN was a licensee only. Section 20 of the Compulsory Purchase Act 1965 provided that if a person had no greater interest than a tenant from year to year in the land, then that person was only entitled to compensation for that lesser interest. Held, the court combined the interest of a parent and its subsidiary for the assessment of compensation following a compulsory acquisition. So Lord Denning, MR, observed, seeing that a licensee can be turned out on short notice, the compensation payable to DHN would be negotiable. Lord Denning further observed that where a parent company owns all the shares of the subsidiaries, it can control their every movement. The subsidiaries are bound hand and foot to the parent company and must do what the parent company says, he continued. So here, this group is virtually the same as a partnership in which all three companies are partners. They should not be treated separately so as to be defeated on a technical point. They should not be deprived of the compensation which should justly be payable for disturbance. The three companies should, for present purposes, be treated as one, and the parent company, DHN, should be treated as that one. Lord Justice Goff upheld an appeal on the basis that DHN had an equitable interest in the land under a resulting trust. For his lordship, the case was one which required the realties of the situation to be looked at to pierce the corporate veil. Lord Shaw held that DHN and Bronze had an identity and community of interest. Lord Denning, MR, Lord Justice Goff, Lord Justice Shaw.
Okay.
And that was a portion of what they had.
Right. So they termed it as a single economic unit.
Yes.
Yeah. Okay. Thank you.
You're welcome.
Let's move. Who's next? I think it's Yvette.
Hi, good morning.
Good morning. It's afternoon. The cool.
Is it?
You wrap up in a.
I'm not wrapped up in a blanket, but I wish I were.
Go ahead.
Okay, because I'm still in morning mode.
Oh,
okay.
Lord.
So my case, I'm trying to go between screens, so please forgive me for any lapse. What I found was this case came in the lower courts, and then it went in on appeal. The name of the case is, let me see if I can pull it up here. The name of the case is Abdul Ghani El Ajou and Dollar Land Holdings Limited, Factorum NV.
Okay.
And I tried to summarize the facts of the case. The parties on appeal. So I'll talk a little bit about the case when it came on at the lower level and what happened on appeal.
Okay, go ahead.
So the parties are Abdul Ghani El Ajou, who in the final judgment or the final appeal decision is the appellant, and Dollar Land Holdings Limited, Factorum NV, who is the respondent. Briefly, Mr. El Ajou was a very, very wealthy Arab businessman, and he was a large investor in a project with a company called Dollar Land Holdings Limited. I'll abbreviate it as DLH. And the investment or the project was to develop property in Battersea. There were 3 Canadians who carried out a massive share fraud in Amsterdam sometime earlier. Those proceeds of the fraud were invested in the joint venture to carry out the property development project at 9 Elms in the Battersea in conjunction with DLH. The interest of the Canadians in the joint venture was bought out by DLH in 1988, which then became the sole owner of the development project. When the nature of the fraud was uncovered and the proceeds were tracked by Mr. Abdul's attorneys into the development project, Mr. Abdul launched a claim in the lower court to try to reclaim some of his monies. He had been the largest investor in the project, although he was not the only investor. For their part, DLH at the trial denied that in 1986 it had any knowledge that the money which the Canadians invested in the project represented the proceeds of fraud. They further asserted that in buying out the interest of the Canadians in 1988, they were a bona fide purchaser for value without notice of the fraud. And so therefore they were claiming in that instance that even if the fraud did occur, they were clear to own that whatever share as they were bona fide purchasers because they had no notice that there was a fraud, no knowledge of the fraud. So DLH, so the claim of, what do I have here? So again, I reiterated that DLH denied that in 1986 it had any knowledge that the money which the Canadians invested in the project represented the proceeds of fraud. And a lot of what we're discussing today in our company law sessions is whether or not knowledge of a director or an employee with authority could be imputed to the company. And so that's why it was so important that DLH jumped up and down trying to separate themselves from having knowledge based on the fact that the director, Mr. Friedman, had the prior knowledge of these Canadians who had been already found guilty of a fraud. And the proceeds of the investment was from that fraud money. So the claim in the case was to enforce a constructive trust on the basis of knowing receipt. For this purpose, the plaintiffs, and I'm just going to go into a little explanation of what the Lord said needs to be determined in order for there to be success in this case. However, as I would have said earlier, for our company law purposes, we are here to determine whether or not there was a knowing receipt or knowledge on the part of the director and whether or not that imbued any knowledge to the company. But anyways, the Lord said that for the purpose, the plaintiff must show first the disposal of his assets in breach of a fiduciary duty to be successful. Secondly, must show the beneficial receipt by the defendant of assets which are traceable and representing the assets of the plaintiff. And thirdly, which is our important point, is that knowledge on the part of the defendant that the assets he received are traceable to a breach of fiduciary duty. So the principles established, just in brief, with respect to this case, they were laid out on appeal as well as in the lower court, but they were whether for the purpose of establishing a company's liability under knowing receipt, head of constructive trust, the knowledge of one of its directors can be treated as having been the knowledge of the company. And there were two principles that were carved out: the directing mind and will principle and the agency principle. So for the directing mind principle, a company having no mind or will of its own, and this is just what we call dicta or what the Lords would have said in rendering their judgment, just to give us clarity. A company having no mind or will of its own, the need for it arises because, the criminal law often requires mens rea as a constituent of the crime, and civil law, I think I may have jumped to a point, sorry. But let me finish reading this point. And the civil law, intention or knowledge as an ingredient of the cause of action or defense. In the off-quoted words, please forgive me, I didn't intend to read that part, but this is talking about directing minds principle as it applies to both company law, civil law, as well as criminal law. And it says that in criminal law, it applies, and what the courts look at is mens rea, whether there was an intention formed by the person who committed the wrong. And in civil cases, directing mind principle is hinged on knowledge as an ingredient and as an ingredient of the cause of action. I'm going to skip on to what the justice said in the case of Vicon Hadlane in Leonard's Carrying Company Limited and Azatec Petroleum Company Limited. Vicon Haldane said, "My lords, a corporation is an abstraction. It has no mind of its own, and more than it has a body. It has a body of its own. It has no mind of its own any more than it has a body of its own. Its active and directing will must consequently be sought in the person of somebody who, for some purposes, may be called an agent, but who is really the directing mind and will of the corporation, the very ego and center of the personality of the corporation. The doctrine attributes to the company the mind and will of the natural," that's end quotation. "The doctrine attributes to the company the mind and will of the natural person or persons who manage and control its actions." That is a quote by Mr. Justice Millett. "Their minds are its mind, their intention, its intention, their knowledge, its knowledge." The Lords were quick to point out that it is important to emphasize that management and control is not something to be considered generally or in the round when we think about this doctrine, okay? It is necessary to identify the natural person or persons having management and control in relation to the act or omission in point. So this principle was laid out by Justice Everley when he delivered a judgment in a criminal court case called Regina and Andrews Weatherfoil Limited. He said, "It is necessary to establish whether the natural person or persons in question have the status and authority which in law makes their acts in the matter under consideration the acts of the company, so that the natural person is to be treated as the company itself." So they're clarifying that not just any Joe Blow who works in the company can imbue or have their mind or their knowledge or be considered directing minds of the company. But it should be based on the proper status and authority of the individual in that company. Decided cases that show in regard to the requisite status and authority, the formal position as regulated by the company's articles of association, service contracts, and so forth, though highly relevant, may not alone be decisive. Mr. Justice Millett adopted a pragmatic approach in indicating this. So in the case that we're discussing, the Alajou case, the Court of Appeal said that each of the steps that were taken by the director, Mr. Ferdinand,
Yvette.
Yeah, I can't
was
hear
elucidated.
anymore.
Hi.
Hi.
Yeah, you dropped for a second.
Yeah,
I'm
you
back.
Yeah, you're
Yeah,
back.
you're back now.
Okay, so sorry about that.
That's okay.
The last point, and it's very brief that I'm going to give you because I think I've spoken a lot just now, is the
No, this-
agency.
This is a long case.
Yeah, it is a long, and I'm so sorry, but it was very complicated, and there are a lot of complex facts about tracing funds up and down from Amsterdam to Switzerland to London, and I just carved out all of that because I mean it was a lot.
Mm-hmm.
So forgive me if I'm not as fluid on all of the facts that you guys may go back and look at when you do look at this case. But the final point that I believe would be necessary for us as we consider company law in this particular session is the agency principle that was discussed. And the question was whether Mr. Ferdinand, who is the director in question, whether his knowledge ought to be imputed to DLH, the company, on the ground that he acted as DLH's agent in the transaction. The appeal court stated that they agreed with the judge in the lower court that even if Mr. Ferdinand was DLH's agent, his knowledge could not, as a matter of law, be imputed to it. And that's based on those facts of that case. But it is established on the authorities that the knowledge of a person who acquires it as a director of one company will not be imputed to another company of which he is also a director, unless he owes not only a duty to the second company to receive that information or that knowledge, but also a duty to the first company to communicate it to the other company.
Correct.
And so the facts of that, right. And so the judge's decision with respect to not caring whether or not Mr. Ferdinand was in this instance an agent, it all hinged on the facts of that case, whether or not he had a duty. So duty also comes into play with the agency principle. But again, there's a lot more meat in the judgments that I have not cited here in my brief summary. And with that, I rest. Ms. Archer.
They can
if I
read
may
it,
be
it's
of any,
long.
yeah, it's long.
It's long, but it's an interesting case because it speaks on different principles. And have the opportunity, they did sit down and read it. It's not, I mean, it's not that long, kind of long.
I can send it. It's a very, I thought it was like what, 23 pages?
Yeah. You read the Supreme Court and the Court of Appeal?
I read the Supreme Court in brief, and I read the Court of Appeal in length. And I will say that this case seems to have been overturned as well, that this is no longer good law. And I would want to discuss that, I guess, later. We could determine if this is true, what I'm looking at, but maybe not good law on some other principles, but I think maybe not the company law principles. I didn't explore that deeper, but because that just came to light this morning for me.
Okay. All right. So we'll come. Who's doing Guilford and Jones versus Left? I have a name here. If she's here. No, she's not here either. Okay, what about, he's not here either. Who's doing Lord versus Grace? I have Deshawn. I don't think she's on. Okay, Trico, is it back to you, MCA Records?
Ms. Archer, I must admit, I looked at this case, but I couldn't understand it. I would prefer to deal with Meridian, but this case was so long and convoluted. It had to do with intellectual property rights and things like that, and I couldn't see what it was, what was the relevance to the case at hand.
Remember, I said the excerpt was already in the book, the relevant excerpt that we needed. So don't focus on that one. Do Meridian.
Yeah, okay. It had to do with, anyway, I can give you some background. Somewhere around 1990, a group of people in New Zealand, Malaysia, and Hong Kong, 3 jurisdictions, tried to gain control of a company in New Zealand. The company was Euro National Corporation, and they wanted to use its assets for its own purposes. Included in this was 2 Hong Kong investment managers called Norman Koo and Norman Wu Sui, who were employed by Meridian Global Funds Management Limited, Management Asia Limited. The scheme required a purchase through apparently respectable New Zealand merchant banks for a 49% controlling interest in ENC, also known as Euro National Corporation, for a larger sum. Their intention was to fund this purchase out of ENC own assets, but they required bridge financing to fill the gap between buying the shares and gaining control of the company's money. This was provided by Ku and I don't know how to pronounce NG, out of funds managed by Meridian. So Meridian is recognized as a Hong Kong investment management company, and Ku was its chief investment officer, and the other gentleman, NG, a senior portfolio manager. The scheme to pay Meridian Bank out of the ENC's money on the 19th of November was frustrated by the independent directors of ENC, who opposed conditions imposed on the use of the company funds with which what they call it the predators did not comply. So the two gentlemen, unable to get their hands on the company's money, they had to unwind the scheme as best they could. So it was therefore not necessary in this case to inquire into whether Ku and NG could have been described in some more general sense as a directing mind and will of the company, which is Meridian. But their lordships would wish to guard against being understood to mean that whenever a servant of a company has authority to do an act on its behalf, knowledge of that act will for all purposes be attributed to the company. So what they're saying here is because there are two employees who have authority to do something, it doesn't mean that every act they do on behalf of the company is the company's act.
Mm-hmm. Okay.
So they were able, so because these two gentlemen whose names unfortunately are tongue twisters for me, Ku and NG, because they were able to go outside the company and put together a scheme, they were really fraudsters. And because they were fraudsters, their act could not be attributed to the company's act, as the company's act. They didn't inform the company of what they were doing, so the company had no notice of this illegal or fraudulent transaction. So that's basically it. The courts would not attribute their fraud to the company. So Meridian Global Funds Management Asia Limited was won on the appeal. Let's put it that way.
Mm-hmm.
Okay, so that's it.
Mm-hmm. Okay. And the cases are quite interesting, right?
Yes, ma'am, it was. These gentlemen, the background to this, these gentlemen were working real hard to try and put their hands on 18 or 19 million dollars worth of funds. They were trying to gain control of this New Zealand company, they would then, because they were 49% shareholders, they would be able to control it for their own benefit. But they wanted to use their company's funds to make the acquisition, and they were going to try to replace it by acquiring this interest in this New Zealand company. They were going to pay it back, but the board of the company called ENC became aware of this fraudulent act and refused to release the funds to pay back to Meridian Global Funds Management. So everything unwound. They couldn't do anything. They couldn't complete the transaction, but they were involved in a fraud. So Meridian couldn't be responsible, as far as I can see, for the loss.
Okay.
Mhm.
And Yvette, you said in the first class, always try to talk about the good that people do in companies. So let's see if we could find in any of these cases anything good. Because sometimes these matters go to court, they're not good.
Right, you're right. When they end up in court, they're certainly not for good reason.
No.
But yeah.
Go ahead.
No, was just thinking unless, of course, there is an allegation made against somebody who is really innocent.
Yes.
You know?
Yeah. I don't know of much instances where that happened, but it's always some fraud. It's always someone doing things that they should not do, or they think that what they do should be done, but they do it anyhow. But like cases from Trigo, these people they see an opportunity and they have to figure out a way in how to get it, and they'll do things. And if they get away with it, they'll.
Yeah. I think sometimes though the law moves
slow.
Swiftly. No, in instances where people have been for generations acting in a particular way, right? And then suddenly a new nuance in the law materializes, and acts that would have in the past been fine become criminal or adverse, seen as an adverse action.
Yes.
Right.
Mm-hmm. Yeah, because a lot of things you could have done in the past you cannot do.
Right.
Yeah. Now consider criminal.
Things with gifts, taking gifts, etc. I mean, that's going in a different direction, but
it's because before you could have accepted gifts of any amount, and it was not considered one conflict of interest. It was not considered that you were doing someone a personal favor. But today, no, $400 is that, and some anything.
I think what we, as the law develops, it ought to have taken into consideration certain nuances. Like if it's a quid pro quo kind of situation, you look at it closely. But if someone is just deciding I want to give a gift to just a client or, but anyways, it is what it is. And the law progresses and
then people are not aware of it.
And people are not aware.
Okay. Is Kristen on? Yes. Kristen, your go, multinational gas.
Yeah, I'm here. Just give me 1 second. I just find a video for it, so I'll just copy it and put it in the link so everyone will have access to it, and then I'll just go through it briefly.
Okay, go ahead.
Okay.
Wow.
So this
Multinational Gas and
gas.
Petrochemical v. Multinational Gas and Petrochemical Services Limited, 1983, CH 258 is a leading United Kingdom.
Okay, Trico, you playing it.
Yeah, so I just hit it.
Kristen, you want us to listen to the video or you have a summary?
No, I have a summary.
Oh, okay. I wasn't sure what you wanted us to do.
Yeah, I have a summary. Thanks anyway. Do you have a summary? Okay. Is multinational gas and petrochemical versus multinational gas and petrochemical services limited. So the facts of the case is that the plaintiff formed multinational gas. It was a joint venture formed between 3 shareholders to engage in trading, storing, and shipping liquefied natural gas. Originally, the company was to be incorporated in the United Kingdom, but after taking tax advice, it was incorporated in Liberia. Multinational gas and petrochemical services, referred to as services in the judgment, was incorporated to act as the broker agent. The board of directors of the plaintiff, the company was composed of appointees of the 3 shareholders. Although the business was initially successful, later it collapsed with its liabilities exceeding the value in assets over 113 million GBP. As a liquidator was appointed to examine ways in which the company might seek to recover against third party and the benefit of the creditors. The liquidator brought proceedings to the against services alleging negligence in relation to the provision of the financial information to the company. In the same action, it was also brought against each of the directors alleging negligence in failing the obvious deficiency of the information provided by services and making highly speculative and negligent decisions. So the judgment in the case was that although the case is remembered primarily for the statements with respect to the company law, referring to both judgments and the judgment of the company law, the act decision of the Court of Appeal was required to make related procedural point. So basically what happened in this with the judgment was that they were trying to sue services and the directors stating that they were held liable to the creditors of the company because they were negligent in the facts. So they were trying to pierce the corporate veil and try to hold them accountable to the creditors when in reality, the directors, they only have accountability to the company that they have a fiducial responsibility to the company instead of the creditors. So the cases that were cited in here was Press versus Petrodel. Basically, we have them trying to pierce the corporate veil as well. Okay, so that's it for me.
It's for you. Okay. And then others can watch the video. Is Aniska on?
No, she said she was having internet issues.
Okay. Bethel? Yes.
Boy, listen here, I wish I was having internet issues right now, because child, you all sound good. I find none of that stuff what you're talking about. Anywho, let me tell you what I found.
Seaboard?
Which case?
Sorry? Mine is Seaboard Offshore versus Secretary of State for Transport. I wasn't able to find much on this, and I'm still getting this echo, so it's driving me crazy.
Okay,
but what apparently happened, it appears that the chief engineer of a ship wasn't familiar with the machinery and equipment in the ship that he was responsible for. And apparently some type of, I'm assuming, environmental accident occurred. And the company Seaboard Offshore Limited was taken to court. They were sued, I guess by the state, on the basis of the Merchant Shipping Act 1988, which stated that the owner is liable for unsafe operation of the ship. The Lord Kendall, who was responsible for the case, he didn't agree. He felt that the act was not intended to mean that the, oh my Lord. Sorry, this thing is driving me crazy. The act was not intended to mean that the owner of the ship was responsible for all of the acts of everyone, all of the staff and management of the ship. So the owner did not hold personal liability for everything that went on with the ship. The issue that I have, and this, this isn't related to what was determined, is if the owners didn't have personal liability, then who was liable for the action, for the disaster that occurred? I'm thinking it must be another section of this Merchant Shipping Act that they maybe should have used as support for their case, other than the portion that they actually used. Because someone has to be liable. I know in cases locally, for instance, we've had cases where we've had oil spills and shipping companies may have been sued and fined and made responsible for the cleanup. But us as Bahamians, like, where's our recourse? What do we get out of it? If the government receives, say, maybe $10 million, and the environmental impact on us as Bahamian won't be resolved for another 50 years, what happens? Because not only are we impacted, our heirs are impacted as well, because it could be that we can't fish, we can't eat, we can't fish, so we can't sell no fish. So all of this is impact on us as Bahamians.
I think, Ms. Bethel,
it's a limitation of the law.
with respect to your question, Ms. Bethel, who's responsible, if I may, Ms. Archer?
Sure.
I don't know I haven't read that case, but in some instances, there are contracts between the actual owner of the vessel and charterers who would have chartered the vessel to carry carry their clients' goods about. And so while it may not have, and I don't know what the detailed facts of that case is, but in some instances, it's really the charterer and not the owner of the vessel who's responsible. And so maybe
that brings me to my point, that maybe they sued on the wrong grounds.
Absolutely. Maybe they brought in the wrong party.
Yeah.
Yes. So that's a nice, I think that's a nice case to look at.
Yeah.
But
I didn't find much on it though. I kind of just improvised. So I mean, maybe there's more stuff out there that I haven't found yet.
So was the decision that the person who was operating the vessel was brought before the court?
The decision made by Lord Kendall was that he said, the act does not impose the carrier's liability on the owners of the ship for the omissions of their reasonably and properly instructed agents or employees. In other words, the owner did not have personal liability for everything done in the operation of the ship.
Because they should have gone probably behind the charterer.
Yeah, exactly.
Well, it seems to me that she's saying that what he's saying is that the employee, the chief engineer, was responsible because the ship owner did everything that it could to ensure that there was proper operational standards applying. But somehow I believe this chief engineer did something that was outside of that. So how can you hold the owner responsible for something that an employee does? It's like if you give a man a car to drive and he jump in the car and he go all over the place and he get in an accident. Is that the responsibility of the person who owns the car? Or is it the person
that he doesn't
driving?
know how to drive, but he take the key?
Well,
it seems to me that's what happened in this case, because the chief engineer, they said, did not have sufficient opportunity to familiarize himself with the machinery and equipment. So personally, he should not have taken on that particular job.
well,
No, but the company is responsible as well, because they should make sure that their employees who they are putting in place are fully trained. And they should do this by way of doing the usual trainings and having people, I mean, they could clear their knowledge, their responsibility by ensuring that the training is done, ensuring that those who are trained are signing off on the training modules and classes. But it's the ultimate responsibility of the employer to ensure that the people they hire are trained to do the job.
well,
So they shouldn't be able to get off on that.
well,
And also
Mr.
there is vicarious liability, where if you're driving, to Mr. Trico's point though, if you're driving a vehicle and you go on your merry way, if on your merry way, was a part of your assignment, your employer could be held vicariously liable for the wrong that you did operating their company vehicle.
Yeah,
So,
but if you've come off your route and you're driving recklessly and you're not supposed to be,
even in some cases, there are rulings where the employer is held responsible, where the driver would have gone off of their route.
well, I can't answer for bad judgments.
Yeah.
But all I can
Yeah,
say
well-
is that if you get in an accident and you're not in the course of your duties, the employer can't be responsible. Now, I can't say that when you get into court and somebody drag you into court that the company doesn't pay because they don't want to be confronted with all kind of legal fees. So they may just say, well, just let me pay this and get out of here. Because they're in the business of defending lawsuits. They're in the business of making profits for their shareholders. So oftentimes people don't pursue their just rights because it ain't worth it financially. So I don't know. I would come back to Ms. Bethel to find out what the judgment was because I didn't particularly understand what she was saying.
Okay, so it says here, in the little summary, it says, in this case, a company is not vicariously liable for the failure of the captain of the ship to comply with the Merchant Shipping Act, Section 31. The section was not framed so as to give rise to criminal liability of an employer for acts of an employee in such circumstances.
Right.
They have-
So the person in charge, the captain, didn't follow the Merchant Shipping Act. So the company, he was supposed to, he was employed to do that. So the company who owns the ship can't be responsible.
They said that section didn't give rise to criminal liability of an employer for acts of an employee in such circumstances.
Yeah.
So that means acting in
Yeah,
that.
but the company is who was sued. The captain wasn't sued, they went after the company.
Well, then in that case, they couldn't succeed against the company because it was the captain's fault.
Exactly.
Right.
Captain's fault.
Because
So,
back started when we said they sued the wrong body.
all right,
Yes.
okay, now I'm
And
with you.
perhaps, I think Yvette mentioned, perhaps they also used the wrong application. Perhaps they
Yes.
could have sued under another legal
Absolutely.
authority.
Sorry,
Know what I
yeah.
mean?
Absolutely.
Yeah, so
Yeah.
I think both Yvette and Miss Bethel are correct in that regard.
Yes.
Absolutely.
You might be able to argue that the captain was the company's agent. So I don't know. But then you still left with the problem of, did the person execute his job properly? And if there is sufficient guidelines to show, instructions to show that a person should have followed certain guidelines and his company policy and is established, how could the company be held responsible? Can't.
For and against. For and against.
For and against.
Yes.
I think Miss
We
Bethel,
have-
you said
we
you
have
couldn't find
justice.
a lot, but this sounds like a juicy case. So I think
It does.
we should really read further on it. I
We
mean,
can
I
get-
certainly want to.
I intend to go through it some more because this this doesn't make it too much sense to me. So
Oh, I could see the point because I mean the judges can only respond to what the application is. It can't
Exactly.
go off. It can't go off on a tangent and
That's
tell
right.
the person who's the claimant or the
Choose this one.
that that you should have used this particular avenue. That's
Yes.
not for them to do. They give
Right.
advice then, and
yeah,
they
but
are
what
order.
if they had brought the case against the engineer? I mean, if I am an engineer and I'm going to be held responsible for all these things, I mean, do I even want to take that job?
Oh, I thought
Unless I have some type of, insurance coverage, some liability or indemnity.
well, I misunderstood the point as to the
No, that was just
duties.
that wasn't related to the case. I'm just saying, because I
Yes.
said, well, obviously they should not have sued the company that they did, but somebody is, of course, ultimately responsible.
Yeah.
In this case,
They shouldn't have,
to my mind,
clarification,
it's the
they shouldn't have
engineer.
sued under that provision
Right.
They
Mhm.
shouldn't have sued under that provision.
Because that provision seemed to get strict liability, and so
Absolutely.
they should not have done it. But it's a case,
Yes, it sounds like a very interesting case.
a good one. Okay, Kadrin, it's up to you. Standard Chartered. Kadrin. Ah, she's there.
Sorry, guys. I didn't realize my mic was muted and I was talking. So again, good afternoon, everyone. Ms. Archer, I actually gave my attention to number 48, the one you had initially given to me. I didn't get to 42, the Williams versus Natural Life Health Food.
Go ahead.
Okay, so this was a case that concerned negligent advice given by a one-man company to a commercial fruit grower. And despite the proper application of the spray that was used for the crop, it ended up killing the plaintiff's crop. Now, the company was found liable in contract and tort when the case went to court. And then also the question arose that whether the beneficial owner and the director of the company was personally liable. So here are the facts surrounding this case. The plaintiffs entered into a franchise agreement with the defendant company, which was Natural Life Health Food Limited, the managing director, who was also the primary owner and control of the company. The franchise agreement was submitted to the plaintiff by the encouragement of the managing director, and also in particularly the director sent a brochure, prospectus, and financial projections to the plaintiffs and encouraged the plaintiff to set up the franchise. Now, the brochure described the company's system as, and I quote, a proven concept. And in addition to that, the company also sent the plaintiff detailed projections. And the projections demonstrated the likely future profitability of the plaintiff's shop. So the plaintiff, Mr. William, was so encouraged by this that he ended up entering into an agreement and entering in the franchise. Now, however, the plaintiff's business did not prosper because of substantially less profitability. And as a result, the plaintiffs brought an action against the company for damages of negligent misstatement. Now, during the course of the legal proceedings, the defendant's company went into liquidation, and the plaintiffs then sought the personal liability of the defendant company's managing director, the primary owner, the shareholder, and the controller of the company. Now, at first instance, the court held that the company was liable for the negligent advice. Thus, the managing director was personally liable in a sum of £85,000. The Court of Appeal upheld the lower instance court's findings. Now, the case then went to the House of Lords, and the issue here when it went to the House of Lords was whether the director was personally liable in negligence on account of the failure of the franchise. So the court then held the House of Lords, they reversed the findings and noted that the managing director could not be personally liable in negligence. And in the present case, there was no personal dealings between the director and the plaintiffs. There was no evidence that the director assumed personal liability for the success of the franchise. Thus, in the absence of the assumption of personal responsibility, the director was not liable for a failed franchise committed by the plaintiff's company. So it was a lot of reading too on this case, and this was as far as I would have gotten.
Okay. So in the end, Mr. Williams' claim failed.
Right, yeah.
Mhm. Yeah.
Yeah, which I find surprising seeing that he had all the material that the company would have sent him that helped him to make his decision, that would have held in court.
It's just like a IPO, initial
Yeah.
initial public offering when you have
Yeah.
what you call a prospectus. Well,
Yes,
the
yeah.
company that issues it says this is not for investment. This is not my advice for you to invest in this company. This is a company that's putting out, that wants to raise some money, and this is some information that might help you. But there ain't no guarantee in this.
Yeah, it would do.
This is only an aid. And so you can't, after you invest, hold the company responsible unless there is some negligence or some obvious misrepresentation in the information given. But to
Yeah.
provide an investment group of people who want to invest in a company with information as to projections, et cetera, you're at risk.
Yeah, yeah, the ultimate
So-
responsibility was on the on Williams himself, the franchise,
Right.
when he went into it to make
I
sure.
think
So my question for this one is, my question for this one is, oh, I don't think,
You're on.
Yeah,
hello?
yeah,
We can
Ms.
hear-
Ramin, go ahead.
We can hear you, Yvette.
You can't hear us now.
Yeah,
She must be having
she's
Hi.
talking to the dog in the background.
I can hear, but it sounds like
Yeah, she may be on mute and don't know it.
failure. Hello?
Yes. Hello.
Okay, I'm back.
Mhm.
For a
No,
moment, we had dropped. I was just wondering, with respect to the case, the decision, it seems as if the claim had moved away from the company as it had fallen into bankruptcy and then moved toward the director or the manager. And on that point, it failed. Is that
Yeah.
what happened? Not so much that the company was not liable, but just that the company went into liquidation. And so therefore it didn't make any sense to move forward with a suit against the company. And the claimant moved to the director/manager. And pardon me?
He went, okay, so he first, just like you said, he sued the company,
Right.
for, right? And before the suit could be finished, then the company, Natural Life, went into liquidation. So
Mhm.
they sought to sue the managing director and the main shareholder personally. He wanted to
Right.
hold them liable.
Mhm.
Because he was saying that Mr. Mislin, who in the brochure had been held out as having a lot of expertise.
Right.
And he had
So,
given all,
yeah. I'm not hearing.
oh Lord. Oh,
Yeah, there was an attempt here to pierce the corporate veil and to
Yes.
get directly to the managing director.
yes.
The lower court and Court of Appeal were both of the opinion that that whoever the managing director, who's probably owns substantially most of the company, and the company was the same. But that's not the case, because as Solomon shows, the company has a separate personality, its own legal personality. And the managing director did not assume any responsibility for the information or assume any responsibility for success of a franchisee. He just gave information. Now, if he would have said, "This is a sure thing, man, you're gonna make money," and yeah, that's being silly. That's coming outside. That's coming outside of your protection, and so you're personally liable for those type of statements. But apparently, he never gave that information, that kind of guarantee, to Mr. Williams.
Exactly.
Mhm.
Exactly. Because 9 said, in the present case, there were no personal dealings between Mr. Mislin and the plaintiffs. There was no exchanges or conduct crossing the line, which could have conveyed to the plaintiffs that Mr. Mislin was willing to assume personal responsibility to them. Contrary to the submissions of counsel for the plaintiffs, I am also satisfied that there was not even evidence that the plaintiffs believed that Mr. Mislin was undertaking personal responsibility to them.
Mhm. Yeah. Yeah, so, you know, it just goes to show you have to be careful what you say when you're meeting with people you're
Yes.
doing business with. You got to be careful. Have your lawyer there. So you don't,
Better get it in
you don't-
black and white, because I don't think handshake deals are legal anymore.
No, well, the problem is you can have a written contract, but if you engage in other statements about the viability of your project, you're adding to the contract.
Yeah, but you have to prove that statement, that I made that statement.
Well, that's the whole point. That's where you get into court. And they ask you, sir, when we were in the boardroom and we signed the contract, didn't you say that this was a sure thing and you're going to be a rich man and all that? Didn't you give me? Oh, before I signed it, let's put it this way. Weren't you encouraging me to sign it because you were in effect guaranteeing me financial success? And if he could show that Mr. Mislin made those statements, then Mr. Mislin himself is
But the
on.
paperwork that you signed said that you're responsible for the extent of your commitment.
Yeah. What I'm saying is it's based on the facts, I believe. I'm not an expert, but you can have statements being made that can be incorporated. Verbal statements can be incorporated into a contract. In other words, you're making representations to encourage signing the contract. Ms. Archer, you agree with me, or am I totally falling off the limb?
No, you're not.
A promise is a comfort to a fool.
No. Well, yeah.
Yes.
Mhm. You know, but if that means you only lost $100, that's one thing. If you out of pocket for 100,000, you can be talking to your lawyer about this promise this man made me. You know.
Yeah. You will. Who's this next one? Sharia? Is she here? No. Who looked at Press versus Petrodel?
I did, actually.
Hey,
This actually was an interesting case.
very interesting. I hope you read it on to page 45.
For all 45 pages, is that what you said?
Yes.
No, I sort of yeah, this was the case of Mr. and Mrs. Press getting married. And they were in love for a long time, and all of a sudden, as happens no, I shouldn't say that. They got married. Let me just put it this way. Let's stick to the facts and
Yes.
stop embellishing this story. They had married in 1993 and divorced in 2008. Mr. Press did not comply with the orders of the matrimonial, of the family court for full and frank disclosure of his financial position. And the companies that he owned did not file a defense. So Mrs. Yasmin Press, she went under claim on the Matrimonial Causes Act 1973. I won't go into the sections, for ancillary relief against the offshore companies owned by Mr. Michael Press. Mr. Press formed some offshore companies and put his properties in what I could see in the individual companies.
Yes.
It's a way of investment. So they got married. He did this, and then they got married in 1993 and divorced in 2008. Well, he was contesting her claim for half his estate.
Mm-hmm.
So the Matrimonial Causes Act 1973 says that for a court to be able to order a transfer of property, Mr. Press had to be entitled to the properties held by his companies. Mr. Press contended that he was not entitled to the properties. So what he was saying was, I can hide behind the corporate veil. These companies, you can't say I own the properties because my company owned the properties, right?
Right. And they're
That's what
separate.
he's saying. So in the high court, that's a good argument, man. He trying to get out of Spartan with $18 million.
Mm-hmm.
So in the high court, they said that he had the ability to transfer the properties in practice. So she was entitled to them under Matrimonial Causes Act. And the court therefore had jurisdiction to make a transfer order.
Question, did he own the properties before he got married? Or after he got married?
In the course of his life.
Yeah, right. So some were before and then some was during.
Yes, it doesn't matter. He owned the properties. It doesn't matter when he got them. He owned them, and he wanted to divorce. He and his wife wanted to divorce. She was asking, as a wife normally would, she being reasonable only for 50%.
So you're saying from birth to his current age, his wife can claim 50% of all of his ownership?
Well, okay, yes. This is the matrimonial court. You gotta stop thinking about.
I didn't know that. I'm just asking. I didn't know that.
Yeah, whatever the man owns, he has to. In the Matrimonial Causes Act, and I am going out on a limb, you have to disclose your assets.
Yes.
And there's an argument about what you own and what control you have over these assets, right? So Mr. Press is saying, yeah, I own the company owns the houses, but I don't have any direct control over them. They are different, they're separate from me. It's all Solomon and Solomon rule, right?
Mm-hmm.
You get it? So now, the Court of Appeal anyway, they went to the Court of Appeal, and then the Court of Appeal allowed an appeal to the Supreme Court, or I guess what you call House of Lords. They call it Supreme Court now in the UK. The Supreme Court unanimously overturned the Court of Appeal and held that Mr. Press beneficially owned the assets in Petrodale Resources Limited companies under a resulting trust. Now, there's another area of law that's coming in because he contributed to their purchase. So there was no need to pierce the corporate veil, which could only be done in limited situations. So the lords are being very careful here. They don't want to use this principle of piercing the corporate veil in every circumstances.
Exactly.
They want to get away from the idea as needed and to do justice and all that, because Solomon and Solomon principle is very important to company law. So you can't allow everybody to start jumping behind that using this corporate veil piercing. But what the lordship in their wisdom says, well, let's look at it. This man formed these companies, he bought these houses, and he owns these houses. And so the houses are owned by him in a resulting trust. He's using them, and that's his wealth. He contributed to the purchase price. So we don't even have to go behind the corporate veil. He had been entitled to the assets of his companies under resulting trust. And under the Matrimonial Causes Act 1973, the court has jurisdiction to transfer half the value of the properties to Mr. Priest. So the Matrimonial Causes Act looks at all the husband or wife's assets, even properties that are held in trust, because he was using it for his benefit. So he couldn't deny his wife that he wasn't benefiting from these properties. So that's the sleight of hand, if you like to use that the House of Lords used.
Yep.
And Lord Sumption said there was only a limited power to pierce the corporate veil. So you see where they're moving with this.
Mm-hmm.
Namely, when people are under an existing legal obligation, which is deliberately evaded. So you got to be, that company has to be formed to evade a legal purpose.
Yeah, but I think that's what they got him on as well, because they had asked him to produce the documents and he didn't do it. And the company.
No, he just didn't want to comply. He was playing the fool. You know, I ain't divulging all of this. He's playing the fool. So he didn't. In the end, he showed that he owned these companies, but the court said, but when, I don't know if you know much about trusts, but if you come into an asset, it could be called a resulting trust. There's another area of law. So he owned these companies, he owned these houses and these companies, and they were for his benefit and the benefit of his wife. When they were divorced, everything that he had title to through equity or whatever had to be disclosed. And the court then was going to divide it based on the Matrimonial Causes Act, which had sections 23 and 24 had a wide application. So they could go after any property he had in a resulting trust. So what the House of Lords is doing here is saying, we don't want to get involved with piercing this corporate veil in this instance. We have basis on a resulting trust. This man is he provided the money for it, he purchased it, he got married, whether he had them before or after, and he was using the houses for the benefit of he and his wife. So they were, and they're, in their opinion, using the Matrimonial Causes Act, they were properties of the marriage. And so he had to cough up. So that's they're being very clever here, because they don't want to have this, piercing the corporate veil, they don't want it to become a legal concept. They don't want it to become a go-to every time there's a problem. They're using other remedies to get around this idea. And so the resulting trust was one way of getting around this man trying to say that these houses he bought and was using in his matrimonial life can't be touched because they're under an incorporated limited liability company. So, buddy, welcome to the new world. Boom.
Mm-hmm.
That ain't fair though, eh?
Mr. Trico, all I think is, like, you're discouraging men from getting married.
Well, the thing is, well, apparently you see what's happening.
If guys just stop.
Well, by there you see what's happening in the world today. The European Union and the OECD and all that, they clamping down on us. That's the same sort of thing. Men in the UK and United States and men in these Arab countries, wealthy men, they want to put their assets all over the world, and they want to hide them and
Conceal.
Yeah. And what's happening is some people, it becomes a question of whether you're avoiding or evading. It's the purpose of forming the company. If you're forming a company to hide your wealth, that's evasion. Now, you forming a company to avoid, I don't know.
Not to pay.
That's right. Right. If you're just forming a company and you're using the law to avoid a tax, that's legal. But if you're forming a company to evade a tax, that's not illegal. I mean, I getting a little off track here, but the whole idea that this gentleman's companies, they were legit, but they weren't going to pierce the corporate veil to grab those properties from him. They're going to say he was using the properties, and he was using his properties in his matrimonial endeavor and tie up with his wife. And so that was matrimonial property when you applied the Matrimonial Causes Act 1973.
Mm-hmm.
He held them on resulting trusts for him, and I guess he and his wife, or whoever was his wife. So Boom, that's it.
Yeah.
I thought that was very interesting. So, you know, it's you
So let's,
you think you're protecting yourself by putting your house in a company's name, but you gotta be careful about that,
yes.
you know.
Mm-hmm.
All right, I talked
Yep.
that to death. Sorry about that.
No, but that is the case that they refer to now. When you read a lot of cases on piercing the corporate veil, they refer back to Press versus Petrodel.
I see.
And
Okay.
yeah, they're not just piercing the corporate veil just to pierce it.
Right.
Find a different
Yeah.
way in order to solve the issue.
Right.
All right.
Yeah. Yep.
So if we've finished with unit 1 now, everybody understand the general concept of company and company law and the Solomon principle, and that a company can be liable under criminal law, contract law, and there are instances where the court will pierce the corporate veil, but that is not something that they do frequently.
Yeah.
Okay, so now let's move on to different types of companies.
All right.
All right, so you have private companies and you have hybrid companies, you have public companies, you have statutory companies. So a private company can be limited by shares or it can be limited by guarantee. So when it's limited by shares, the liability of the members is what they contribute towards the payment of the debt. That's the amount that they invested. For a company limited by guarantee, the liability is limited by its constitution. And whenever you hear the word constitution, referring to the memo and arts. And so their liability is limited to the amount that they have undertaken to contribute to the asset when the company is wound up. A company that's limited by guarantee don't have shareholders. They just have members. And they're normally private companies and not public companies. So normally a company limited by guarantee can be a non-profit company. Or you could use it for other things like associations or educational or charitable purposes. So though the membership is limited by guarantee, they still have limited liability. They still have a separate legal, have a separate legal personality. And so that allowed the ownership of the property and the contractual rights and obligations without attracting personal liability to its members. The Articles of Association govern the membership of the companies limited by guarantee, inclusive of the duration of their membership and any events which will terminate the company. And of course, a nonprofit company is by guarantee and is normally used for charitable purposes. And with charitable organizations, they prohibit the distribution of profits to its members, either by way of dividend or in a winding up. A hybrid company simply means is limited by shares and guarantee. A public company is the company that has actually gone out for investors. And it can be limited by shares and by guarantee. So when we say that it's going to the public to issue shares, it could be a private placement or it can be a public one. Both of those in the Bahamas means that you have to apply under the Securities Commission legislation. A private company is prohibited from offering its shares and securities to the public. A statutory company is a company that is already incorporated under the Ibc Act or the Companies Act, but now for a particular purpose. They're now going to be incorporated under another statute. And an example of that is a segregated accounts company or a SAC or a limited duration company. So a segregated account that is normally used in the securities business, and it's where you separate the assets and liabilities of a company from its ordinary accounts or general accounts. So the legislation allows you to operate segregated accounts with statutory division between the accounts. So that means that if the company is sued, it is sued against its own general account or sued against a particular SAC.
Mm.
The result is the accounts will be self-dependent. So only the assets of a particular account may be applied to the liabilities of that account. So the divisions between the accounts do not create separate accounts or separate bodies. So because they are SACs, registered as SACs, don't mean that they're separate bodies. What they actually achieving is a single company, what could be achieved by incorporating subsidiaries. So instead of taking the route of incorporating subsidiaries or companies underneath the main company, they segregate the assets of the account holders. Or they could do it by creating a floating charge over certain assets. So a SAC consists of a general account, which contains the assets and liabilities, and they're statutorily separate from the assets and liabilities of the other segregated accounts, or one or more segregated account. So to form a SAC, you could be either a CAC, a Companies Act company, or you could be an IBC. To apply to the Registry of Companies, you have to be registered as a SAC with the prior consent of the primary regulator. So you have to be under the investment fund license with the Securities Commission. You could be issuing securities with the consent of the Securities Commission, or you could be an insurance business, or you could be subsidiary of a bank, or engage in any other business, long as you have the consent of your primary regulator. The next option is a limited duration company under the Ibc Act. And that company actually has a life of 30 years. And it's really directed towards a certain class of US investors. So it is structured properly. It actually is characterized as an LLC, a limited liability company. So under the Companies Act, companies limited by shares or limited by guarantee or both. Nonprofit companies are limited by guarantee and incorporated under a specific provision under the Companies Act. And public companies are also incorporated under the Companies Act. So being mindful that a company, once it's filed its memo and arts and paid the requisite fees and received its certificate of incorporation, it is a separate legal entity. And so that company must have a registered office in the Bahamas. It has to maintain its corporate documents at the registered office. And those corporate documents include the memo and arts, the share register, the minutes of meetings, and resolutions. It also must have 2 directors and 2 shareholders. The officers of the company can comprise a president, a secretary, and a treasurer. Although the act itself, there is no statutory requirement for any specific officer. So generally it's the secretary or an authorized person under the provision of the articles, who is required to affix the seal of the company to certain statutory documents. And you know, we just had the recent amendments under the Companies Act and the IBC Act, which states where a seal is no longer necessary, especially for contracts. So the Registrar General has his e-service. And of course, you know, the first step to incorporating the company is to send in the availability of proposed company names. That's normally done by the financial corporate service provider or the registered agent. The next thing is that under the company's name, it can be in words, it can be in numbers, it can be dual name, it can also be in a foreign language. You can also reserve the name instead of words, you can use numbers. Reservation of the name is for 28 days. And it can be extended for 2 periods of 14 days each. So even though the Act speaks to the filing of the memo and arts as the only document for incorporation, as a matter of expediency and convenience, most people file both the memo and arts at the same time at the Registrar General office. The Act requires that an affidavit be executed by the witness or the subscriber of the memo and arts, and the statutory declaration must be prepared and attested by a counsel and attorney who notarized the affidavit and must be notarized before another attorney or notary. The objects of the Companies Act must be any activity that is lawful under the laws of the Commonwealth of the Bahamas. And the turnaround time for incorporation of a company, I have there 24 hours. And most of my students tell me I should put it to 48 because it doesn't happen in 24 hours. The date of incorporation of the company is the date of the memo and arts are filed at the registry. So companies are normally the corporate vehicles that are used by local businesses who wish to conduct business in the Bahamas with limited liability under a valid business license. Of course, you know, you have to obtain a national insurance number prior to obtaining a business license. The business license is required under the Business License Act and for anybody carrying on business in the Bahamas. To obtain that, you have to complete the business registration form, submit proof of citizenship of the beneficial owners of the company, copy of certificate of incorporation, copy of the certificate of registration from NIB, a copy of the lease of the property, a copy of certificate of sanitation from the Department of Environmental Health, and the initial business license fee. If you're going to use a trade name, that is not registered separately, and it can be included in the business registration form under the Business License Act. So companies are required to file an annual statement, and in that annual statement, you would confirm the shareholding of any change in shareholding, directors, and officers of the company. A proof of seal is required upon filing your first annual statement of the company at the registry. And the annual statement should normally be completed and filed within 14 days of the company's AGM. An annual return declaring whether or not 60% of its shares are beneficially owned by Bahamians also has to be filed by the 1st of January of every year. And a company may also be required to register for VAT if the business is providing certain goods or services that are subject to the VAT regime. A company should have at least 2 directors, and within 3 months of incorporation, the directors of a company limited by shares or guarantee having a share capital shall be directors and call a general meeting. The shareholders meeting should be held in a place as is provided by the articles. Or in the absence of any provision, at a location within the Bahamas as the directors determine. The meeting of members of a company may be outside of the Bahamas. If a quorum is not present within 30 minutes of the time appointed for the meeting of members, the meeting stands adjourned to the same day 2 weeks thereafter, at the same time and place. And if at the adjourned meeting, a quorum is not present within 30 minutes of the appointed time, the members present constitute a quorum.
Mm.
So now I just mentioned VAT. There's a section on VAT. We know VAT has decreased from 12% to 10%. But a business is required to register for VAT if it is in business, and the goods and services that it provides is considered taxable supplies. And it either makes the taxable supplies and the total value of the taxable supplies for the previous 12 months have exceeded the VAT threshold, which is 100,000. Or it considers that at the beginning of any 365-day period, the total value of the taxable supplies will exceed the VAT threshold in the next 365 days. So VAT registration should be completed within 14 days of meeting the foregoing requirements. And the controller for VAT registers within 21 days of the application for registration. So once registered for VAT, a certificate of registration must be displayed in a conspicuous place within the business establishment. And a tax identification number or TIN must be quoted on the business sales invoices. Only VAT registered businesses may charge VAT. Businesses that don't register for VAT when it is required to do so will still be considered a taxable person. The VAT regime offers a voluntary registration under VAT for those businesses that may not be required to register for VAT, but may or intend to make taxable supplies or claim a refund of VAT if charged by their supplier. Businesses may also register for VAT as a group. And I think the rest on VAT you know very well. Common now. So let's look at the IBC. The IBCs are corporate vehicles designed for commercial, corporate, wealth management, property holding, trading, insurance, investment purposes for businesses. It is a unique product. The Bahamas was one of the first centers to offer this type of company, which is geared towards international businessmen. So IBCs may be used as a part of a complex arrangement of trusts. It can be used with foundations. It can be used with family offices and other specialized vehicles for financial planning, private client, and wealth management objectives. One of the key features of the IBC is confidentiality. So a businessman doesn't have to use his name as he transacts businesses or transactions around the world. He just uses his IBC.
Mm-hmm.
So an IBC can apply to be registered as a limited duration company. And of course, under the Act, if the company has at least 2 subscribers or 2 members, it can continue either to be an IBC or convert from an IBC. If the company was not already incorporated as an IBC prior to the application, the memo of the company must limit the company's duration to a period of 30 years or less. Be mindful that under the Preferential Exemption Act 2018, all of the exemptions for limited duration companies will fall away. So a company ceases to be a limited duration company if the registrar issues a certificate of dissolution or issues a certificate of incorporation, which records a change of name for the company that does not include the words LDC or limited duration company. Or if a company passes a resolution or alters its memo in arts or cancellation of registration. especially if it exceeds the 30 years, then of course it's canceled. So under the IBC legislation, IBCs are no longer prohibited from conducting business with Bahamian or from having an interest in or lease or real property in the Bahamas. They remain versatile corporate entities of international. So no person other than a bank or trust company can incorporate an IBC unless that person is licensed and approved under the Financial Corporate and Service Providers Act. IBCs may maintain bank accounts with banks operating in the Bahamas, subject of course to due diligence and KYC and other certain documentary requirements. They also establish and maintain professional contact with attorneys, accountants, and other consultants who practice in the Bahamas. So you can see that IBC is a very lucrative business in the Bahamas, because not only does it assist the trust companies and banks having them as clients, but also for all of those entities that are licensed as financial corporate service providers who provide company administration for these companies. So that's why you see a lot of law firms also have a corporate arm. So they not only they do the legal work, but they also have the arm that does the corporate administration.
Yeah.
So incorporation of IBC is a very simple. Again, it's done electronically. Incorporation is completely by registration at the Registrar General, a memo and arts in which 2 persons or more subscribe for the shares, and they also provide a certificate of compliance. Upon registration, the registrar issues a certificate of incorporation, and the IBC is then legally in existence, and of course, it can commence operations immediately. So similar to the incorporation process for a Companies Act company, one of the first steps in incorporating an IBC is, of course, to check for the availability of the name, reserve the name. And just as in the CAC, the name can be in words, it could be in a foreign language. You could use symbols, you could use distinctive marks, to get accents or characters. The company, again, like under CAC, can be reserved for 28 days or extended for 2 periods of 14 days each. The IBC Act also allows person to forego the name reservation for intended company. And the turnaround time for an IBC is stated to be 24, but they say in some cases it's 48. So the annual fee for an IBC may only be paid by the registered agent, and the annual fees for any given year due on or before the 31st of December of the preceding calendar year. And IBCs may be struck off the register of companies for non-payment of fees by the 31st of December. And you know, the Registrar General just went a few years back, going through a whole process of striking off companies for non-payment of fees. Be mindful that no fees will be accepted for a current year unless all the outstanding fees for the prior year has been paid. So it's just like paying for your driver's license. If you haven't paid it for last 5 years and you want to renew it this year, you have to pay for all of the years before. So an IBC may be limited by shares, guarantee, unlimited, limited duration, or it could be registered as a SAC. The memo on arts provides the name of the company, the location of the registered office of the company, the location of the registered agent, a statement of objects, the authorized capital. It also talks about the classes of shares to be issued, the number of shares to be issued as registered shares, and the currency the shares will be issued in. The ultra-virus doctrine does not apply. So when you read the memo and arts, it just says that it's for any, the object or purpose of the company is to engage in any act or activity that is not prohibited under law. So in the past, instead of those wordings, it would actually state the what exactly the company was going to do: sell groceries, sell and repair tires. But no longer do they use that. It's just long as whatever is profitable, that's what it states. Now, when you get the business license may be more prescriptive, saying exactly the nature of the business that you are in.
Right.
So an IBC can amend their memo and arts by the shareholders or the director's resolution where it is permitted. Only registered shares are allowed for an IBC. Bearer shares are prohibited. And you know, all of that came about from 2000 when we started to change our legislation.
Mm-hmm.
International pressure was on bearer shares. So we've moved from bearer shares into other matters for reasons why IBC should be taken off the market. Share capital, there's no minimum authorized capital required for IBCs. The authorized share capital of an IBC may be divided into various classes of shares, each with different voting, dividend, and other rights. A capital may be denominated in any currency, and the shares may be issued in fractions, in registered form only, and may be of no par value. Unnumbered shares are permitted. An IBC may reduce its capital by resolution of its directors and with the necessity for an appropriate order of the court. An IBC only needs one shareholder. There are no nationality or residency requirements for shareholders. Meetings of the members may be convened by the directors or by the members holding more than 50% of the votes or such lesser percentage as prescribed in their memo and arts. They can be held within or outside of the Bahamas. Members may attend in person or by proxy, by telephone, or any other electronic method. All meetings may take place within or outside the Bahamas. An IBC is only required to have one director, who may be an individual or a company, and such director need not be a Bahamian resident. The subscribers to the memorandum elect the first directors, and the memo articles govern the subsequent appointments. Meetings are convened by the directors and may be held within or outside of the Bahamas. The directors may attend in person or by phone or by electronic method. IBCs can also indemnify their directors against all proceedings against them, provided that they acted honestly and in good faith, and always with a view to acting in the best interests of the company. Now, we know that IBC still affords its beneficial owners confidentiality, but you know, with the latest pressure from the international arena and the OECD, some of that confidentiality has been eroded under the Register of Beneficial Owners. And so there is a movement afoot. There's a draft document that just came out this week, again, speaking about movement towards knowing who are the beneficial owners of vehicles that are being used around the world. An IBC is required by law to maintain a registered office and a registered agent in the Bahamas. The minutes of the meeting and the copies of the resolution of directors, members, and officers, a register of directors and officers are to be kept in the registered office. An IBC also must have a corporate seal, an imprint, which is kept at its registered office. So an IBC must maintain copies of the memorandum and articles of association. They must have the register of directors and officers. They must have a share register at the office. And the register of directors and officers must be filed with the company's registry of the Registrar General's Department. along with the compliance certificate.
This register of beneficial owners would then become a public document.
No, our legislation has it whereby it is not public. The information is submitted in the portal, and in order to access that, you have to go through the office. It is not for the public.
Okay.
Now, recent discussions in December is that they want all countries to have public registers. And they actually had on the conference call, I think it was 2 or 3 jurisdictions that have a public registry for ownership of companies. Some companies voiced their opposition to it because they said that some of these companies are owned by very wealthy person. One of them, I think in South Africa, the daughter of one of their companies was kidnapped, and they asked for ransom for quite a few million of dollars. And that is why they said they do not want a public registry. Other companies in South America say that it's open and they don't have that issue. So it's a mix between the two, but the push, especially from those who are working in the tax arm of the 10 and G20 countries, is they must have a public registry in order to tax their citizens. So the story is not over yet.
What happens if the beneficial owners is a trust company? It was a trust company or something like that, or a trustee. That's still not. I mean, a trustee is holding assets for the beneficiaries. So,
Yes.
but legally, the trustee is the owner of the assets.
Yes.
So, and the register of beneficial owners, the trustee name has to go down. And sometimes a trust company is the trustee. So is another way of getting around it?
Well, I'll tell you the same way they have done CRS. They take a stance and they chip at it piece by piece.
Yeah.
So they're starting now with the IBCs and similar products in other offshore jurisdictions that are like the IBC, which is a versatile tool. And they found that these IBCs has been used for illicit means. Once they're able to obtain a public register of IBCs, then they're going to go behind other structures. They chip at it, chip by chip by.
Yeah, because I've seen documents where they say where eventually you have to get to the natural person. You can't be using companies and entities all over the place. If you have 50 different labs or companies, eventually they want the natural person.
Yes. Right. So everything now is natural person.
Yeah, but I was thinking in the case, say it's a trustee and holding for beneficiaries. Sometimes the trustee is not allowed. It has in the trust deed, it says that the trustees, the beneficiaries listed won't get any money for 20 years. So can that person who's a beneficiary be said to be the natural person to receive it today, or you know what I'm saying, or in a year's time?
But see, don't forget now, you got to look at it. It's different arms. So yes, he's going to receive money in 20 years. When that information is uploaded, and if a question arises, they're looking at that beneficiary's account. They're looking at that hit that account and where is it coming from. So if there's no money's coming from to that account, that person is safe. But the minute that hit that account 20 years from now, they want to know where that money is coming from.
Yeah. All right.
Okay, so I've listed after that some of the features of an IBC. These are the features that I guess goes with, in most jurisdictions, it's the same. You know, the exemptions that are provided and how you can do business with ease and the minimal filings and reporting requirements, because it really is a very easy tool to use to do business. And that is why it attracts so many, I guess, honest and other persons.
Yeah.
But it is if you're operating, let's say if you are an intermediary, which means you connect buyers to sellers in any product at any stage of a supply chain. And the best way for you to do that is to have a company and a flexible company. There's no lot of filing here and filing with government here and registration there. No. As long as you pay your annual fees, your annual statement is filed, you have your end of year resolution, it's fine. If you decide at the end of the day to guess what, I want to get out of this business and I want to do something different, you could change the name. Or you could take that same company and you could transfer the shares of that company to someone else. So the beneficial owner has changed. And then the registered agent would record the change in shareholder. It's a very flexible instrument.
Yeah, so in other words, you're saying that if you have a trading company and you're tired of dealing in tires, selling tires from United States to, I don't know, to Trinidad, and you want to get out of the business, all you do is sell the company to somebody in Trinidad who wants to buy it.
Who wants to do it, yes. Because when the supplier sees that name, they know that ABC company is a company I've been dealing with for a very long time.
Yeah. Right.
And business goes on.
So you're saying that transfer is very easy to do?
Yeah, it's very easy.
Yeah.
Because there's a contract between you and I. I'm telling you how much I'm selling my company to you for. Only thing from a registered agent point of view is that you have the resolution that I have sold my company to XYZ. Here's the KYC documentation for the client.
So, so you would then just notify your supplier in the United States that you now ABC company is now owned by XYZ.
Yeah.
Okay. I mean, they would, by courtesy, they would have to know that the person they're dealing with is no longer the original person.
Yes.
Is that a formality, or is that just a formality, or is that a legal requirement?
It's practice.
Best practices.
Yes.
No, because I mean, somebody could acquire a company and you think that it's the same company you're dealing with, unless you're actually signing a document in correspondence.
That happens, and that is how that segues into Unit 3, which we're about to talk about now, client due diligence requirements. Sometimes that happens. You don't even know who you're dealing with.
All right, okay.
That's the way in itself. So this chapter here speaks about client due diligence requirements on fronts. One, we're getting a lot of international that the corporate vehicle, IBCs, and trusts are being used as a means to launder money. They're being used as to support terrorism. Not much in the Bahamas for proliferation of weapons of mass destruction, but it is used in other jurisdictions in the East for that purpose. And so that means that in the Bahamas, we have to make sure that, one, we know our clients, two, we have documentation on our clients, and three, that we know what the law states when it comes to money laundering and terrorist financing. So the first thing is you have to know what money laundering is, and I know everybody knows. Correct?
We get examples on TV all the time, but yeah, I suppose so. Yeah.
Okay.
I mean,
We know,
I've seen where somebody stole someone locally. Somebody stole from Shell $198,000 through a check, and when the police caught up with him, they charged him with money laundering
yes.
because the person took the cash and he went and bought a Buick LeSabre and a bunch of other stuff. And they said, well, you not only did you commit fraud, but you'd committed money laundering because
Yes.
we're able to trace all these assets that you put this money in. So
Mhm.
I thought that was I mean, that's just local. I always thought money laundering, you had to have somebody from another jurisdiction, you know?
No.
You think about narcos and all that, you know?
Oh, no, 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 no. Money laundering is much deeper than that.
Yeah.
Okay. So there are 3 stages of money laundering: placement, layering, and integration. So
Okay.
when
Go on.
bought the integration. So placement is the physical disposal of the cash proceeds that have been received. So let's say if you are selling drugs. So you sell the drugs, you get the funds. Then layering is separating illicit proceeds from the source by creating layers of transaction. So let's say you deposit some, you spend some, you invest some.
Mhm.
Integration is when you actually, after you finish layering, you're able to wash it, whereby when it comes out, it then appears to be legitimate.
Mhm.
So that's why you'll see some people who are in illicit business, they have businesses that are lucrative in cash,
Mhm.
because then you can take the illicit funds and put it in that business. So when it comes out as if these are proceeds from my restaurant business, my laundry business.
Yeah. So in that case, they're willing to pay VAT or tax or business license fees on that money. Is that what you're saying?
No, 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 no. You have a legitimate business, a business that is registered, is licensed. You have clients in. So let's say on average, your daily amount you make at your business is 5,000.
Mm-hmm.
You have illicit business coming in where you make 10,000.
Mm-hmm.
So when you decide now that you're going to pay bills and do things, you're going to mix the two together.
Mm-hmm.
So your funds go back out as legitimate money, as if all of that funds was legitimately made in your business operations.
Mm-hmm. Okay.
Only until either the drug squad start to investigate you somewhere along the chain supply for drugs, or a bank decides to say the figures that are the amounts that are coming in does not go with the business.
Right.
Other than that, it is unassuming and money just flows.
Yeah, I understand what you're saying now. So in other words, the bank asks you for your financials and you show $1 million in sales, but your deposits that year equal 2 million.
Yeah. Or what they do is they do a comparison. You're
Mhm.
selling peanuts, someone else is selling peanuts, and someone else is selling peanuts. They make $2, but you making 10.
Yeah.
What's different between you and them? So they'll do a site visit
Mhm.
and they'll say, oh, he has a different type of clientele
Yeah.
in peanuts. Why? He has high traffic. Why? Well, let me taste his peanuts and taste the other peanuts.
Yeah.
My peanuts are sweeter.
Yeah.
People. Okay, so under our Proceeds of Crime Act, it defines what we call an identified risk offense. And under the act, it says that includes corruption, that includes cybercrime, that includes human trafficking, money laundering, financing or proliferation of weapons of mass destruction, and terrorism or the financing of terrorism, or any other risk identified by regulations. So this is an ongoing process. where the Bahamas is doing is national risk assessment to identify is there any other risk of money laundering or human trafficking or corruption or any type of financing that is going on in the Bahamas that the international arena will identify as a risk and not do business with the Bahamas. So it says under Section 9 that it is an offense if you have knowledge or you have reasonable suspicion and you conceal the proceeds of crime, or you disguise it, or you convert it, or transfer it, or remove it from the Bahamas. It is an offense. It's an offense if you know, you suspect, or you ought to have reasonably known or suspected that you've entered into or you're entering into an arrangement that facilitates the acquisition, retention, use or concealment, or the control of proceeds of crime by or on behalf of another person.
Well, you know, okay, Miss Archer, say
Yeah.
you own a car dealership. You sell in well, let me use Porsche because I don't want to subscribe. Nobody here is a car dealer for Porsche. And you know, a known criminal comes into your organization and puts $100,000 down and say, I want that
Yeah.
Tesla or I want that Porsche.
You said
You're laundering money for that guy, right?
yes.
Okay.
Now, the key word you said was known. Notice what the act says. You suspect or you reasonably have known, which means that you would have heard his name before around. The majority of people know him. Once you speak with that person, it is an offense.
Ooh. Yeah, well, you're just opening up opening up my eyes. I thought I knew about money laundering.
Yes.
Or I thought I knew the rules, even suspected people.
No, so let's say you know your cousin deals drugs. He comes and he says, "Man, I bought 2 watches. Let me give one to you, cuz happy birthday," and you take it. What you think?
Yeah, well.
Okay. That also includes your spouse.
And his girlfriends.
Yes, someone brings gifts, buys you gifts, you accept them, and you know you ought to reasonably have known that they could not afford it.
So what you're doing is you're accepting the proceeds of a crime. That's what you're saying.
Yes, you are.
Yeah.
Yes, you are. See, it says here under Section 11, it says it is an offense where a person knows or suspects or ought to reasonably have known or suspected that he acquired or is acquiring the proceeds of crime, use or is using the proceeds of crime, or possessed or possesses the proceeds of crime.
El motto.
It's all around. It's telling you don't touch. Now, it is an offense if you fail to disclose to the FIU or to the police that you know or you suspect or you reasonably ought to have known or suspected that another person was engaged in money laundering or was committing an offense of any one of the identified risk. So you see all this human smuggling going around. A lot of people know.
Hi.
Hi.
In here. I just took off the microphone because I wasn't sure if you were checking the chats, but with the part where you said reporting to the FIU, isn't only the appointed reporting officer who is registered with the FIU as a contact of reference, or are they only the ones who can report to them? Because I thought not anyone could just go to the FIU with suspicion of money laundering or any.
No, order to police.
So you
To the-
could go to, so if you want to, and you don't have a point of reference who's in communication with the FIU, you could go to the police and they would take it from there.
Yes,
Mhm.
you can go to the police.
Okay, thank you.
And of course, you know, the MLRO, the appointed person in the organization, it is an offense where they know or suspect or have reasonable grounds for knowing or suspecting that another person is engaged in money laundering. And so the person,
Could I
go ahead.
interrupt you? You were saying under this failure to disclose, you said if you knew somebody was smuggling humans or humans, that's an offense under
Yeah, you need to disclose it to the police.
oh right. So they're doing an illegal act to obtain money by smuggling. That's what you're saying.
Mm-hmm.
Right, okay. Even though it's, well, of course, not even though it's humans, but yeah, okay, all right. Yeah, all right, thank you.
Yeah, there's a lot of illegal activity still going on in the Bahamas. And when you see those things are published in the paper, don't forget now the paper is online. So that is read by the international arena.
Yeah,
So we have laws in place and these crimes are still going on. I mean, it's natural in other countries. Crimes go on everywhere. But this island is very small.
yeah.
And of course, it is an offense if you tip off a person that they're under investigation.
Right. So you can't be no snitch on the other hand.
Okay,
on the
so-
other side. Mhm.
No. So
And that's so small, everybody know everybody.
I know. And someone will say, I saw him going over there to CDU, you know.
Uh-huh.
That's
It's
it.
true. Yeah.
So people are afraid. And another thing is that there's so many families, large families. No one wants to talk on the other person. And so crime perpetuates.
Mhm.
So under the FTRA, we have customer due diligence requirements. And that means that whenever a facility is offered, whether that be in a bank, in a trust, in a securities business, as a financial corporate service provider, you have to be able to identify that person. And you know that the central bank recently in its AML guidelines gave some new requirements. Everyone who is a Bahamian don't have to present a passport. They have requirements where there are other documents that you could present. 2 documents, voters card and NIB card, or your permanent residency card, along with maybe your national identity card. And so everybody who's conducting business has to have to identify who the facility holder is, where their funds are coming from, and if they have large sums of money, where do they obtain their wealth from? Is it from inheritance? Did you sell a home? Did you sell a car? Where did you get your monies from? If you are what we call another entity that is licensed in another jurisdiction, or if you are listed on a stock exchange that has been approved by the Securities Commission, then simplified due diligence is carried out. Now you have some clients where enhanced due diligence is carried out. And enhanced due diligence is carried out on high risk clients and politically exposed persons. So high risk client is one that comes from a jurisdiction where they have identified weaknesses in their AML framework.
Mhm.
And you can find those on the FATF website. Politically exposed persons, again, you can pull down from the central bank their AML guidelines. If you've never read it, it's a good document to read. It'll tell you, it'll identify who are politically exposed persons, as persons in government with authority, judges, police officers, defense officers to a certain level, persons who are working in the as ambassadors around the world, being executives of publicly owned corporations, and these persons, known as PEPs, more or less fall under the identified risk of corruption. So that is what you're looking for. So when you take on a client from this PEP category, that is the first thing that you're looking at. Do they have the capability or the availability to be able to siphon off funds from their current position? Or can they justify the funds that they say that they have based on their current position? So in addition to that, you also have to know who's their family, and who their friends are. Because it actually states that you must not only know the politically exposed person, but you must know all of their family and all of their friends. Because all of them are considered as politically exposed persons, and enhanced due diligence must be carried out. So in addition to that, you also have to look at the country where they were born and the country where they do their business. And then, of course, you must know why they want to do business in your jurisdiction.
Ms. Archer? Ms.
Yes.
Archer, just a point, I'm seeking a point of clarification from you.
Go ahead.
You indicated that a PEP, when you're doing business with that PEP, you ought to know their family, et cetera, et cetera. Is it that when you're doing business with the PEP, you're supposed to know their family, et cetera, or is it that when you're doing business with a client who is family to a PEP, you ought to know that they are family to a PEP?
Both.
Okay.
It's interesting. That's a good point.
And so, yeah, okay. Another question I had, you mentioned person of the judiciary. Well, for all persons. When one does business with let's say a body corporate who has PEPs as directors, is it then the responsibility of the registered agent or whomever doing business with that corporate body to obtain references, et cetera, from the PEP? I guess my question to you is, you talked about having that knowledge of whether or not you're dealing with a PEP. What is then the next step with respect to dealing with the PEP in order to meet your obligations under the Act? What's the next step that you need to do with respect to your due diligence? I know you said identify the PEP. Yes, check. We've done that. After identifying the PEP, what steps does one take further to ensure that one is in compliance with this obligation?
Okay, so say on the application form, you ask the question, are you a PEP? So the onus now is on the facility holder or the individual to identify that they are a PEP. But compliance then has to do its own independent check. And that independent check is not just for a PEP, it's for every client. Because sometimes the person may take no, but when you do your research, you find out that yes, they are. And especially for domestic PEPs, you know from reading the papers, looking at pictures, you know who their associates are. And the same thing internationally, you have to look at pictures.
So all we're doing is securing their names?
No, you do more than secure their names.
No, their names and their identification, and that's the end of the story.
No.
Okay, could you elucidate the point further on what happens after you obtain all of their credentials?
Then you have to do a background check. And a background check means that you run them through a compliance software that gives you the whole history of that person, where they worked, if they were ever sued, if their name was mentioned anywhere, in any article, in any blog. And then you do an independent search on the internet to see again if there's any negative reports on that individual.
Mm-hmm.
And because it is a high risk, or if it's a PEP, it's still considered high risk, and you've done enhanced due diligence,
Right.
it has to be approved by senior management of that company, whether they're willing to accept that risk.
Ms. Archer, is there a standard list of what an enhanced due diligence looks like? Like what documentation would be considered enhanced due diligence?
No.
I know the standard, but
No.
the organization would have to determine that internally. How
Yeah,
much further they can go.
it depends. Okay, if let's say you had a PEP from Argentina, the route you would take in order to give yourself that comfort would be totally different if you're doing a PEP from Pakistan.
I see. I got you.
Yeah, it's different.
I got you. Okay.
Yeah.
Thank you.
Get the basic KYC, or the route that you will take in order to satisfy yourself, it's different. Now remember, when you take that client to senior management for approval, you have to tell a story. And that story has to say in writing, who is this person? And then you have to give a recommendation as to whether or not you think the company should accept this person as a client, and identify the risk if the company decides to accept it.
Understood.
So, right. So that compliance person has to get that comfort within themselves first. That yes, I know this person and I think we're willing to take on the risk. Or they get happy and they said, guess what? This is just too much risk. Let me put this up to management that I recommend we don't accept. Especially if you cannot find any information on that person. Because in today's world, everybody is on the internet, be it good or bad.
Additionally, I think that with regards, if you decide to accept the client and you, for instance, risk the client as a high-risk client, your reviews, your periodic reviews that you would do, say if you do every 2 years on a normal client, for a high-risk client, you would probably want to do it more frequently.
Yeah, you do it, a high risk is normally done on an annual basis, but then it still depends on the risk itself.
Exactly.
If you're dealing with a high-risk client, a PEP that is coming from an oil-rich company, you're not going to do that annually. You have to look at that quarterly. Because that whole area is an area that moves. So after you've looked at just the client themselves, that individual, then you got to look at the market that they're working in. And who are the players?
Yeah, but suppose you have suspicions, but he already got $20 million parked in your bank. What you gonna do with his money?
That's why you file it.
You put a block on the funds. I mean, I would actually happen to be talking to somebody working with Chase or one of them, and they were saying that people actually send them money in the hopes that they send it back.
What do you mean?
Well, that cleans it up.
Yeah, that cleans it, yeah.
Yeah, they send you, one day you see some money sent to your bank to the bank to be on deposit. And I said, well, all you got to do is send it back. She said, well, that's what they want. You have to be careful about that, because if this money is coming from Chase, is assumed to be going back there is assumed to be clean. So the person has effectively laundered the money.
Yeah, and that's a red flag.
Yeah,
You can't deposit money today and want to take it out tomorrow.
yeah.
Yeah, but
Now-
also when you have to return it to sender, you have to return it to the bank that you got it from. So.
No, that-
I don't know the ins and outs, but I just, it is a problem if you're sending the money back, is the person can come and say this money, who receives it says, well, this money is clean because I got it from Chase and that's a clean bank. You know,
So what they do, Lolita, is they don't send it. You're not returning the funds. See, if you're returning the funds, is not a red flag. So let's just say they said expect $2 million, and when the funds come in, they sent 5. Okay,
mhm.
the 2 million when they said it was coming, you were already skeptical, but now you're sending 5. Return the sender. But you have some sending in 2 million. They send in 2 million today, and day after tomorrow they tell you, oh, I have to pay a bill. Send a 1.5 million here and send 400,000. That'll leave me 100,000, and then they'll say, I'm gonna send some more funds. You should have paid your bill before you transfer it.
Yeah.
It's a red.
Yep.
Well, you gotta be awake.
Yeah, you have to be aware because they are slick. They're very slick. So knowing your client and doing due diligence is a very
And
interesting.
sometimes they also like to start off with small transactions before they move to big ones.
Mm-hmm. Yeah.
They want to test the waters.
Yes. And they like to test the waters with offshore jurisdictions.
Mm-hmm.
That is the way they do it. And I don't want you to believe now that there aren't crooks out there, because there's plenty.
Mhm.
Because otherwise the police and defense force and the drug units would have anything to do. So if you would identify that there is something suspicious in the way in which a client is operating, then you file an SDR with the FIU. And you give a story as to why the transaction is suspicious. And if you're able to, you also give them the transaction in question that has triggered it. But you can also just looking at the individual and the way in which that they are conducting themselves. Let's say they're a very pushy client and they don't want to give you sufficient information as to where the funds came from. You can still file with the FIU because the FIU has connection all over the world to trace people.
They also like to get defensive and point fingers at you like you're the one doing the bad stuff.
Are you?
No, the client who's doing
Oh,
the suspicious activity, they like to turn it on you and make it seem like it's you who just don't want to give them the money because you're doing something with it.
Yes. Or you having financial problems? Is this a problem why you can't transfer these funds now?
Yeah, they try to distract.
Yes. So there are all kind of different tactics that they use. So we already talked about the requirements. And like I say, you can go to the central bank website for their AML guidelines. So one thing you have to learn in dealing with companies and managing companies and administering them is you have to know where your clients operate, where they do business. So even though for an IBC, you don't, you're not involved in the transactions, all you're doing is maintaining the records. That FCSP can still expose itself to reputational risk. If that company is exposed somewhere around the world or being sued. Because it comes back again to due diligence. Did you know this client? Do you know what this client is doing? And that's why you must have a system where your clients' names are constantly being checked on a daily basis to see if there's anything negative out there about that company. because it impacts your reputation of your company and also your jurisdiction. Now, you know, some FCSPs, financial corporate service provider, also provide other services.
Miss Archer,
Yes.
no, your job.
It?
Yeah, unless you
What?
weren't talking, I just didn't
Yes,
hear
I
anything.
did. Oh my goodness gracious me.
You were fine for me.
Oh, okay.
I think it may just be isolated.
Oh,
Yeah,
okay.
I
'cause
heard you as well.
Oh, okay. FCSPs also provide, besides being registered agents and registered office, some of them also provide nominee shareholder and also provide directorship. Again, remember that see that as, again, concealing the true ownership of these companies. And like we said earlier, the beneficial owner must be identified and verified, which means you must receive the passport and reference letters. And they push back on reference letters too.
Can I ask a question?
Go ahead.
How, in your experience, how are entities dealing with the passport issue in terms of getting a copy, a proper copy, a certified copy of the passport from
No issue.
internationals who may not be, in front of you?
But don't forget now, when they take up the copy of the photograph, they are notarized.
Mm-hmm.
Yeah, they're notarized.
Mm-hmm.
And
They must
depending
get
on
those notarized.
yeah, and depending, yeah, they have to be notarized. The utility bills don't have to be notarized if they're computer generated, but the passports must be.
Okay.
Yeah.
You could use certification guidelines like that they could follow so that I guess it could kind of help with verifying.
What do you mean certification guidelines?
Yeah, like say like if you wanted a passport to be certified by, and you'd have a list of who you would accept the certification from and what you want indicated on it, because sometimes they'll have people saying, oh, they certified it, and then they have like some signature of somebody saying, yeah, I seen it, blah blah blah. But you could say, well, you want it stamped by the notary, you want their registration number or something, and
yeah, you can.
like you could have a guideline of what you want, and then you could always do like have like compliance do a screening on the notary as well.
Yeah. You can do it that way. And then in the AML guideline, it also speaks as to who can certify. And there's a list, and that list is not exhaustive. So each FCSP or company can make their own list as to who can certify their documents.
Now with the part with you say concealing of having the nominee companies and stuff, but then some businesses who have the SCSP license, they may use that because it may be I guess easier when establishing companies. Like say, for example, if you have just persons listed as a director compared to like a nominee company who may have like several persons authorized to sign, you might have more options of people available to get stuff done.
Yes, that's the ease on the FCSP side. I was speaking from the international side.
Yeah.
Yeah.
Okay.
The OECD doesn't like that. No.
Noted.
Yes, they don't like that. It's easy for us, and I've seen it. It's very easy, especially if you want to pass a resolution and you want to make the changes, you want to file a document. Everything is right there because on the company is another company that belongs to the FCSP, so it's easier.
Yeah, but and like for example, like last year, we've seen where it's easier having more persons available because there was so many directors who were out with COVID. Things needed to be done, so you couldn't get anything done till at least majority. It depends on how you have it set up, who can sign. but you had to wait till they were better to get stuff done.
Exactly. So a company does work.
Yeah.
Yeah, but they don't like that. That's why I said earlier when Trigger made some comments is that this song and dance is not over. And with the pandemic, it's going to get worse. I think the pressure is going to be insurmountable because all these countries need money after the pandemic. They all need money, and they're going to push for what they want.
Yeah.
They're going to push. All right. So that ends my lecture for today. I hear turning of pages. That's you?
I have a quick question, Ms.
Go ahead.
Archer.
Go ahead.
I see there's under KYC requirements, listing additional requirements for US clients and Canadian clients.
Mm-hmm.
Is that where's that requirement listed? Is that
Hold on,
in
let
a
me go to your,
particular?
let me go to your page. Hold on, my pages.
That's in the books?
Yes, it's
Oh, okay.
it's under the section that says KYC/customer due diligence best practices.
That's page 58, I think.
Yeah,
I don't have numbers on mine. I'm sorry.
I don't have any numbers on
Oh
mine.
yeah,
so
I'm
just
looking
give me
at
a
a
second.
digital, yeah.
Hold on.
I found it. Yeah.
I think I saw it earlier, but hold on. My pages are sticking together. Why are my things sticking? Okay, I'm here.
Okay, so I was just wondering, is that laid out in a particular governing document, like under AML rules or something that I can access? Would I be able to access that on the Citibank's website as well?
No. No, this is best practice.
Okay.
Yeah. This is best practice.
Okay.
See, you remember now, after FATCA, you really don't want to be in any problems with the United States. So whenever Americans coming in to do business, that's the first thing you need to ask them of their tax responsibility.
I totally agree, but this is the first time I've seen this listed as, and I mean, and it is a best practice requirement, but I think it's good, but I haven't seen it in the course of my work with real estate transactions, etc.
It is an additional requirement, and you normally request it based on the client.
Okay.
It's not for every client.
Okay.
Yeah, you just.
But it should be for every US and every Canadian client?
No, it depends on the wealth status.
Okay.
Yeah. Because you'll have people come here to do real estate and they're spending 80 to 100,000. Then you have some spending 100 to 250. Then they go 350 to 500. And then they come with the really big amounts, 10, 20 million. And they say they're coming to do some property development. And you could have seen from the last article, I can't remember his name. He was in the papers. He came here to do some development. And it was fraud. Yeah, it was fraudulent. So it's a lot of these things, and these people come with these funds, and it's fraud because they've collected these funds from other persons. And so they come here saying that they're worth all of this money. They have all of this money, but they obtain those funds through fraud.
Understood.
Yeah. Yeah. And that's the attraction to these people for an offshore jurisdiction. This is a very small place, a little dot on the map, some maps don't even have us on it. And they figured, okay, this is a country managing lots of money, billions of dollars. Let's go there. If they were smart enough to rip off millions of dollars from their own people, what do you think they can do when they come here? Okay.
I like that
So-
you said think, what they think they can
Yes.
do when they come
They
here.
don't they don't realize how smart and skilled we are, but they think they can do it. Yes.
Exactly. Mhm.
Yeah. All right. So I hope you enjoyed today's class.
Yeah.
Yes,
Very much, thank
excellent.
you.
Mhm.
Yeah, we had lots of fun today. I
All
had
right.
a question.
Go ahead.
This is regarding, so I know we're supposed to have a project, I think that's what it's called, that's due the day of the final exam.
Yes, ma'am. It will be coming shortly. I like to get a feel
Okay.
for the class first because I have to see
Okay.
where everybody is at. I don't like to make it too easy and I don't like to make it too hard. So I have to get a feel to see where you all are at, and then I write it.
Oh, I don't think I know anything, so.
Don't try. Don't try it. No. Don't
You
try
know, I'm
it.
on this
No.
little island that's barely on the map.
That's all right. That's all right. You'll be getting it. Don't worry about it.
Okay,
Yes,
so,
I'm getting it.
all right.
You'll get it shortly.
Okay, just wanted to know.
Yes, it's coming. I should have said it at the beginning of class, but then I forgot. But yes.
What about the midterm exam?
Oh, you
Are
all
we
supposed to tell
going
me?
have it or not?
You all tell me. Remember, I left that up to you all. I said, do you want a midterm or you just want me to do one final exam?
Well, I was gonna leave that decision to my peers to see with whatever they decide.
I vote for a final exam.
You want just the final
Well,
exam?
a midterm sort of can clue you in as to how much work you got to do.
Yeah, because you said the midterm would only, it'll only be the first beginning, well, chapters, and then the final at the end would be with the remaining chapters, right?
Yeah. Mm-hmm.
Yeah, because it may be, instead of having to study all, maybe easier to break it up, but I don't know.
Well, I'm for that. Also, will it be multiple choice or small question?
Did he listen to my conversation at the very beginning? My introduction? No multiple choice, no fill in the blanks, no going around the corner. None of that.
Oh, okay.
None. You can let me know next week. I haven't written anything.
So it's mostly short answer and long
Short
answer?
answers. Yes, short answers,
Okay.
long answers.
So
Okay.
if we
So
did
it's
do
gonna
a
be an
midterm,
essay question.
Mhm.
about which date would the midterm be? Mrs. Archer, sorry.
Which date?
If we did do a midterm.
Let's see. What's a good date? It'll actually be a take home, you know.
Okay.
Oh, yeah.
Yeah, it's a take home. So it'll probably be like 2 weeks after I issue it.
Okay.
Yeah. So let me know. Next class, you'll tell me.
Well, I could vote. No, I'm for it. That's my vote.
Okay.
Yeah, I'm for it as well.
Okay, so that's 2. Let's
Yeah,
go.
I think I'm okay with the midterm.
Okay, that's 3.
I'm for the
4.
midterm as well.
Okay. Kadrin?
Yes, a midterm is fine by me.
Okay, so we'll do midterm then.
Okay.
We'll do midterm.
And which
That's
day
good.
would that be?
Okay.
You
That's
said
where's
it's for
my-
the first 5 chapters, right?
Yes, the first 5 chapters.
Mhm.
So it's the 5th. So let's just say you could either send it back. Let's say if I send it out on the week of the 12th.
That's March or February?
February. So you
And
can
it's
give
due
it
for the
to
26th?
26, yes.
Return on the 26th.
Uh-huh.
Okay.
Mm-hmm.
Okay, so you say you're sending it out the week of the 12th,
Yes.
and we return it on the 26th.
Yes.
Okay.
Yeah.
All right.
Okay. That sounds good. We're straight. Okay, so yeah. Okay. So next week we'll do company and record keeping 4 and 5 together. Okay. Yeah, we're good.
Both 4 and 5?
Yeah. Yes, 4 and 5. One of them is very short.
That's the,
Company incorporation and corporate record keeping. Come on now, you know you love this course. You read those probably in another hour.
what? I get eye strain, man.
You probably read all already.
I think so.
No.
I think so. He's so excited he has to read them all.
If people don't think I have any life, eh?
No, we're just observing.
Oh, okay. So that's next week is when? What day is that?
The 5th.
5th February. Okay. So
What are you looking for now? How many more chapters?
no, I was wondering whether we're supposed to do anything with this Shaw and HBS private company.
No.
No, okay. All right. It's just it. All right, so we finished then. Is that it?
We're done. Yeah.
Everybody, okay. All right. All right, well, take care.
Okay.
Yes.
You
Nice
too.
Great
session. You all take
weekend.
care. All right then.
Right.
Bye-bye.
Thank you, everybody.
Okay.
Okay.
Okay,
Good evening,
bye.
Nisad.
Watch out for
Good
that.
session, Nisad.
Watch out for that cold weather.
Please, it's no cold area. There's only some breeze blowing.
That's what it seems like. It looks like it's backed off a little bit.
Yeah. It's I think it'll get colder later tonight.
Possibly. Okay. Well,
Yeah.
I won't have to worry about that. I'll be inside.
Yeah, okay. Hey,
Okay, y'all
join the
take care.
others. Join the others in the blanket.
All right.
Okay.
Have a good afternoon, everyone.
We need
Okay,
a
bye.
online blanket.
Bye.
Okay.
Bye.
Good afternoon, everyone.
Afternoon.